Hi there, I'm Adam Horton-Tuckett. I'm the IG Consultancy lead for this organisation called South Central and West Commissioning Support Unit. Just to briefly explain what that is, it's effectively it's an NHS organisation, but our role is to support many NHS organisations like Kevin's in the clinical commissioning group and providers with the sort of bits and pieces they maybe don't have quite all the resource to do themselves, where there can be economies of scale because one organisation can do it once and share it many times. So work closely with Kevin on all matters related to information governance. Related to work within Somerset and other places.
Thank you very much, guys. And if everybody else can introduce themselves in the chat, please, just so that we can save as much time as possible for the discussion after the presentation. But obviously, we are hoping there's going to be a good discussion afterwards. So if when you speak at that point in time, you could just introduce yourselves, that would be absolutely great. So I'm just going to, and I'm going to apologise in advance. With the last workshop, we had, well, when I say we, I had quite a significant issue with my internet connection, and Adam and Kevin had to hold the fort for me. So I'm hoping that that won't occur again, but I'm going to apologise in advance just in case it does. And also to explain why things may be a little bit slow. Right, just share my screen. And as if just to underline the point I've just made, some minutes later. There we are. Oh, sorry, wrong button. Right, hopefully you will now be able to see a slide presentation. I now can't see the chat, so if some lovely person could just assess.
We've not quite got the slide presentation yet, Amanda. It's there you go. Yep,
it's loading that way.
I think there's a 10-second delay behind things. Perhaps hopefully that'll pick up.
I'll try and bear that in mind as I'm moving the slides on for you. So we've introduced ourselves. So just to go into the background and explain how Kevin, Adam and I got to know each other. Last year, as part of our contract for the Department for Education and the work that we did around data, we produced a briefing around the inclusion of the NHS number on the Education, Health and Care Plan. The reason that we did that was because we were aware of a number of local areas who were doing that. We had shared that as good practice because it is such a huge enabler in terms of sharing data. But then we'd had a little bit of concern expressed from DfE because their lawyers had raised issues about whether or not it was legal. So we wanted to make sure that, you know, that the excellent work could continue. So we commissioned a briefing from an SEND legal expert on the position of putting the NHS number on the Education, Health and Care Plan. And what he said was that, yes, you could do it, but you could only do it with explicit consent. So we shared that briefing last year in April, and Kevin was at a session, I think, that we shared it at, and was a bit worried. So over to you, Adam, to explain why.
Okay, thank you. So the slides moved on. So yeah, Kevin brought up to the working group we have across Somerset around information governance this issue about the NHS number potentially needing consent to be recorded on education, health and care plans, and shared his concerns with our working group that I chair, hence why I got involved as well. And just to highlight a few key things around that, your NHS number, as it says there, is unique to you, and the aim of it really is to ensure staff and service providers can correctly identify the right people, match people to records, match data together, match records and other bits of information correctly, to ensure obviously that we don't have any issues of people talking about the wrong person or misidentification or ending up in things that can obviously cause significant detriments. I can tell you a few horrible tales of things in the NHS where the wrong patient's been identified and the wrong treatment's been delivered. So it's useful to have a unique identifier, it's useful to share it. It's been within the NHS for the last 20 years or so. Just said on the previous workshop, when I first came into the NHS 25 years ago, it was called the new NHS number, but gradually it's lost that new title. And it is fundamental to many shared care record systems, of which we've got one in Somerset, we've got loads around the other parts of the country too. And any data sharing does require, obviously, fundamentally to ensure we're talking about the right person. So as Amanda alluded to, we became aware through Kevin's engagement at this stage about the guidance that had been issued and the benefits of using the NHS number in education, health and care plans. We were perplexed and concerned, should we say, about the need for explicit consent for the use of the number, on the basis that actually we seldom see, in fact probably never see, this element saying, yes, you can share data, but for this one item of data you need the explicit consent of the individuals. So with this cross-organisational working, we've looked at data protection and information governance matters, because obviously success in a lot of delivery of health and care services is cross-border working and cross-organisational working. We need to ensure that data flows nicely between organisations where it should and can do. So that's why we meet quite regularly as a cross-organisational group to sort of iron out issues. And that is a group of a number of experienced data protection professionals, etc., who's kind of shared this view that Kevin initially initiated to say, well, we're not quite sure this is right. Lawyers, if you like, if you look at the job description, is probably, in one line, is to argue with each other. So we felt it may be worth putting together a different viewpoint, should we say, and putting that through to the council and saying, we've got some concerns about this, and this is why, and this is how, and perhaps this is a different way of looking at it. And we felt it was important then to challenge this need for explicit consent, just to see if there was something we weren't aware of, or something that the system wasn't aware of, just to make sure that actually it would be useful to do that. And so we approached the council, got in touch with Amanda, and then had a lot of discussions back and forth. So Amanda, if you want to switch across to the next slide. Because what we were concerned about, to give the picture and then give the reasons why we thought there was another way, is when we look at the wording of consent, and particularly if we take the guidance from the Information Commissioner's Office, the regulator around all things data protection, they very much put an emphasis on consent, if you like, being someone having a genuine free choice. In other words, if you say yes, something will happen. If you say no, no impact will happen on you because of that. And take an example, it's often used in things around marketing exercises. If you buy a product and do you get put onto the marketing list for that company, you have a free choice absolutely whether you're on that or not, and that's an absolute genuine free choice. They can't force you to be on it. They can possibly incentivize you if you want to get into that side of things with free offers and cheap things, etc. But is it a genuine free choice? Obviously you don't have any detriment necessarily if you choose not to be on a marketing list. And it is highlighting the ICO's guidance that individuals should not be pressured directly or indirectly into an agreement. And we weren't thinking that was the case necessarily within the CDC side of things, but the group, when they looked at that, thought about, if we ask parents and children for their consent to use the NHS number, is it a genuine free choice? We felt the answer was it wouldn't be. On the basis of that, actually, if it wasn't included because someone said no, there will be some form of impact on that. Not necessarily easy to define exactly what that is, and it would be subjective perhaps to the individuals in terms of the services they have and how it's taken forward. And we weren't thinking of it necessarily from a negative point of view of things would go horribly wrong. It was also a question, well, actually, there must be a benefit for the need to include it. And if there was no benefit, why would those completing the plans and the special education needs statement actually be looking to use it? And so we felt, well, actually, if there is a benefit from sharing it, which clearly there is, and I'm sure Amanda and Kevin will talk about a bit more of that later on, then actually to not include it or give an individual a choice would actually mean they'd lose that benefit if they said no. We can imagine the question being, are you happy for us to include your NHS number? Their response might be, why do you need to include that? Or why do you want to include that? And the answer might be, well, if you don't include it, this might be the case. And so actually, if there's an impact, either from a negative point of view or a loss of a benefit, we felt that isn't genuinely a free choice on that side. So we thought, is there another basis on which this can be used? So taking that further and looking at the next slide, we also thought about, is the NHS number itself sensitive health data? The technical term for that is special category data in the GDPR, but bottom line, we thought, well, actually, if it's been defined as sensitive health data, we thought this might be where some of the advice that the lawyers had given Amanda previously would come from. And actually thought, well, actually, if you look at it on its own, millions of people across the UK have NHS numbers. And they say, if I flash mine up on screen now, would you know anything about my health and conditions? No, clearly you wouldn't. You can't derive anything from that number on its own. That number might be able to be used to obviously pull up records and information in a shared care record circumstance or a cross-organisational working circumstance, but that's probably entirely appropriate. So we came to the conclusion, and this has been debated across the NHS for a few years as well, that actually it's not sensitive data. And that, let's say that's the general NHS view, is the number on its own is not sensitive data. Yeah. And we thought then, okay, when in terms of the legislation, then we one set of conditions potentially to choose from to satisfy the use of it. If it was special category data, we'd have to look at more detailed conditions, but as it's not, we only need to look at what we call Article 6. And the way that works is that public bodies, particularly those supporting children, for example, in education, health and care plans, are established to do certain services, certain functions, and that's usually established in legislation, which Amanda will probably mention later on. So there are what we call the statutory functions of organisations, and data that you need to use to perform those statutory functions is processed under GDPR on this term, the exercise of official authority. It's very legalistic in some ways, but it basically means if you are there to do this function and you need this data to perform this function, that is your official authority to use that data. The key word there being need to some degree. And that's why we then put forward a saying in our response to Amanda when we saw the guidance come out saying, we'd like to take forward a discussion, if you like, about whether the NHS number is sensitive, because we believe it isn't, whether consent should be the basis, because we believe it's not necessarily a free choice, because there is perhaps some lack of benefit if it's not included. And actually, here's an alternative. If organisations providing these services need to use the number, then actually it could be the exercise of their official authority. So that's when we got in touch with the council and put this alternative view for Amanda then to consider and respond to.
Kevin, did you want to add anything at this point, or shall I carry on and you can dip in at the end?
Sorry, microphone on. Happy to dip in at the end. Thanks, Amanda.
Super. Thanks, Kevin. So yeah, fortunately, I think Kevin and Adam got in touch and basically set out a lot of that in an email to me. And to me, I think Adam talks about it so knowledgeably. It really did make me think that hopefully we had found a more permissive approach to sharing data that would stand up legally even. And the main issue around that was that our SEND legal expert had not understood that the NHS number is not special category data, and had misunderstood and thought that if it was on the EHC plan, that it might then give you access to a wider set of information than was actually included on the EHC plan. But actually, as Adam has explained, that is not the case. And you would have to have access to that to those data files through your clinical work in order to get access to any other information on the basis of the number. So yeah, so basically working together, we and with the sort of that in-depth an authoritative understanding that Kevin and Adam had, we drafted a new briefing. And that's just what I'm going to take you through it really briefly. And once I'm not screen sharing, I'll actually put a link to where the briefing is on our website in the chat. So don't worry about taking notes or anything, because it is all there in the briefing. So the most direct and straightforward and permissive basis for sharing data is operational direct care. Now, I think the main problem with data is that it seems to make everybody incredibly nervous, and they are terrified of doing the wrong thing. So I think when people think about the Caldwell review and that permission, they don't always think about sharing data outside of services, individual services, as operational direct care. But if you look at the judgment, it does include the assurance of safe and high quality care and the measurement of outcomes. And actually, Adam, do you want to just talk about the fact that the judgment has been, the guidance around it has been updated?
Yeah, sorry, I was just switching and getting brain back into gear. Yeah, one of the Caldwell principles that was defined and set out in that 2013 review was a new principle then of to share information can be as important as to protect it. And that's when they were really trying to put the emphasis on the fact that, if you like, organisations perhaps being too risk averse with sharing data, and that was causing problems, and in worst cases was contributing to serious case reviews and things that were obviously very emotive and distressing situations for children involved. And then in 2020, the end of last year, the National Data Guardian again reviewed their principles, as they do from time to time, and actually they changed that principle from being that the duty to share information can be as important to actually being the duty to share information is as important as the need to protect it. So they're putting very much a balanced emphasis on that we should share where we can share, and when we do share, we must protect that sharing to make sure it happens effectively. But they really rebalanced that to make it, as I say, just as important as protecting it.
Thank you, Adam. So we'll include a link to that updated judgment alongside of the briefing. So I'm sorry, and just to go back to that slide briefly. So obviously that gives you the sense that you can share data, outside of individual services possibly. But can you do it outside of the NHS? Well, fortunately for us, the Information Governance Alliance, as was, that function's now been overtaken or taken on by NHSX. So the Information Governance Alliance is, or were, the Department of Health, now social care, obviously, NHS England, NHS Digital, Public Health England, representatives from the Information and Commissioner's Office and the National Data Guardian's Office. All of those people sat on that board. So very much this is, government policy, that this is how we should be sharing data. So that they set out in their guidance the context in which the NHS number should be used, and they included, obviously it's illegally required for adult social care records, but they set out in that guidance that they would strongly recommend it for children's social care records, and they also identified that it could be used for preschool and school services to support children with health conditions, and one of the examples they give is special educational needs and disability. So that then starts to give us a real sense of confidence that actually we are doing something that is not only legal, but actually it is being promoted by government as the way forward in terms of sharing data. So extra confidence that it relates to the education, health and care plan. Well, the purpose of the plan is to make special educational provision to meet special educational needs and to secure the best possible outcomes across education, health and social care. So adding the NHS number to an education, health and care plan will support the measurement of those outcomes. And in fact, we can't do it in a holistic way without doing that. So so a really good reason there. And there may be some additional reasons related to sort of effective and appropriate provision of services that local areas may have. So in terms of GDPR, I think Adam has covered this in a really sort of cogent and an easily understandable way. The briefing sort of is slightly more formal in how it talks about this, but this is essentially talking about that issue of official authority. So basically, that if there is an identified need, then the legal basis under GDPR is 6(1)(e), which is that exercise of official authority. And the legal basis to provide that is the Children and Families Act, which does set out that expectation around information sharing and organisations working together to meet children and young people's needs. And if we are ever going to get to the vision of the Children and Families Act, which is about families only having to tell their story once, then this is a really important part of that picture. And as Adam said, the in and of itself, the NHS number is not special category data, so I won't go over that. I feel we've covered that. So I think the other thing that we might want to touch on in the discussion is just obviously it's really important that that there is a data sharing agreement, and we're going to be doing a little bit of work with the Midlands region hopefully next year around data and data sharing, and one of the things that I hope will come out of that is a model data sharing agreement, because where people haven't got them, sort of getting that out of the way, really important point. Just making sure therefore that users are informed via privacy notices that their NHS number will be shared. And finally, the thing that the briefing covers is oh gosh, now I've forgotten the term, is batch requests to the NHS Digital Personal Demographic Service. So if you want to share data across a wider cohort of children and young people than simply those with education, health and care plans, then NHS Digital have a service, and as long as you follow their protocols, which are all very clearly set out, then they will identify send cohorts in health data sets for you. Again, the basis for the request should be operational direct care, but hopefully we've sort of in the briefing given you the grounds on which you can explain why that that is. We've got a case study on our website which goes into a fair bit of detail about how Bedford Borough did this and the benefits of it. I think for given the legal basis for having the NHS number on the education, health and care plan, there wouldn't be any reason that you couldn't also have it on SEN support plans. But obviously, they're not as formal a document, so I don't know the extent to which any local areas may have been considering that. So that is the end of our presentation, and over to you for any. Oh, sorry, and Kevin, just over to you to sort of to wrap up in terms of any final points.
Yes, thanks, Amanda. Not very much really to add. Both you and Adam have very eloquently described the issues that arose, and it was my DCO colleague in Somerset, CCG, who sort of first brought this to my attention, that is there an opportunity, can we take a different view on this? And working with Adam and my colleagues across the Somerset system has enabled us to sort of have this conversation, which hopefully it's all about use of data where there is a defined purpose and you have a need to do so for a real benefit. And ultimately, it's all about benefiting the children and young people with education, health and care plans, and making sure that their care is as joined up as it possibly can be, that data quality element is there, and that we're doing the best we can and working together in the right way. And particularly with the advent of integrated care systems and that drive to integrate, it makes sense to us, and we're really pleased that the organisation, from Amanda's perspective, were willing to sort of be receptive to that discussion and take it forward to this point, that we've the guidance is being amended and looking at that perspective. So thank you.
Thank you, Kevin. And just to say, I didn't explain that earlier on, but we haven't just sort of ignored our original legal advice. We did then seek confirmation from a barrister who was an expert in an expert in data. And they have approved the briefing, and anybody for whom it is helpful, we are very happy to share the legal opinion that they gave us if you are coming across any sort of pushback in terms of whether or not your local area feels able to do this. So we've got a question from Susan. Sue. So Susan, do you want to just pop up and
Hi, yeah, so this is really good because we send all of our advice goes in with an NHS number on, so it would sit within the appendices of a plan anyway. So it is really helpful to provider organisations to actually have local authorities use the NHS number, because quite often they give a date of birth which might be wrong, and we've struggled to then identify the child. But one of the things we're looking at locally is to try and make the annual review process slicker. Could the local authority provide us with a list of children, like they're meant to do to the CCGs, to provider organisations, so that the provider organisation can then identify which services and make sure that advice is then provided? Because we are finding that schools are struggling to do that with parents, and to have a list each term that we could then map against our system would be really helpful. So it's whether or not they could use that, because there will inevitably, that might mean that they send the names of children or the NHS number of children that are not currently known to our service. But it's at the moment we get a list that it has finally in the last term been sent to the CCG, but the CCG are still holding it because they don't know how to then share that with provider organisations.
Right. I'm going to look to Kevin and Adam to see whether they can provide you with an answer, Susan, or whether this is something we need to take away.
Kevin, I don't know if this is something you encounter within the CCG. I mean, I've got a few thoughts, but I don't know if it's something you've already encountered, because CCG is involved in some respects, isn't it? And as Susan has said, that they're sending CCG receiving it in their case, but not sending it on, perhaps.
Yes, indeed. I'm not aware of having come across this particular issue being raised with me before, and I know it's sort of in various other guises. Similar questions have arisen, and sometimes it's. I think we've looked at this in other ways, so that is what, again, it comes down to me, what's the purpose, what is the need, and how proportionate that is, what sort of data, the amount of data that's being shared, and whether it's justifiable to go beyond the just the cohort that you're dealing with. How easy it might be to narrow that down potentially, and if not, then is it justifiable in all the circumstances? Would be my thoughts initially.
Yeah, no, I'd echo that really. And I guess the question for Susan is, if they sent you a list of NHS numbers of children needing for review, presumably you don't necessarily have a service provided to all those children at the moment. So you may have a subset of the numbers on the list. But should you be providing services to all those children, for even the ones that, well, you're obviously providing for some, are there ones that you aren't providing for who you should be providing for if you knew about them?
Yeah, I think as an organisation, we provide for probably 80–90% of children with an EHCP, but not 100%. And that's not because we don't, and that's because they haven't got needs for the services that we would provide, as far as we are aware, because we would expect that if there was a need for the service, a referral would have come in. But the difficulty we have is that it's really poor when we're asked to provide advice for an annual review. So we've already got that, and we already get that list from the local authority into us as a provider for panel before they have an EHCP. But then, as you know, children will come in and out of health services throughout their journey through school. So the services involved vary from year to year, depending on what it is. We've got a very large number of parents that do not speak English, and schools really struggle to identify with parents accurately which services are still involved. So whilst it's a school's responsibility, our experience is that is incredibly poor in our local area. Whereas we've got an electronic system. If we could have a list of NHS numbers, these children are due an annual review this year, we could then run a report, these NHS numbers, have we got any services open? And then it would allow us to then notify those services very quickly. So yes, we would get a list of NHS numbers, but like you say, if we weren't involved with those children, it would only be an NHS number, because if we haven't got them open to us, we won't have them. They won't show up on our system. Yeah. And it would be an exercise that I think does fit with the code of practice. But we're just at that stage that at the moment we've managed to get the local authority have gone to an electronic system. So they, for the first time, are at the point of being able to produce the list. But the code of practice says it has to be sent to the CCG. So it's gone to our DMO. Our DMO is then like, well, how do I get this to providers? And are they breaching? Mm-hmm. Because for us as a provider, we probably see most of those children. But for perhaps our acute provider, they would probably be involved in a lot less. But again, if we only provided the NHS number for those children, the NHS number is the unique identifier that allows every NHS organisation to track that system, or their system.
And it feels like the sort of thing we need to go over for 3 more minutes, and we've probably got time on the call today. But the initial thought was, if you were saying to us that let's say you get a list of 100 NHS numbers, you put them all into the system, 80 of them come back as patients you're providing services to, and you can obviously contact and say, yes, we are providing these. The other 20, if you put them in the system, presuming nothing comes back.
Yeah, so you'd have been sent a number that you ignore.
Yeah, and if you've treated that child for something else that's not related to this, then you'll have their demographics and you know who they are, but they don't have a service. Yeah, so it's kind of one of those good enough approaches, if you like. I mean, there may be times if you had all the time in the world to come up with a better solution that was totally risk averse, but it feels to me, I don't know, Kevin, what your views are, that to share just the list of NHS numbers for you guys to then check which of these you know about and pass back the details of the ones you do, even though in your case you say you know a lot and in other cases you don't know a lot. It feels like one of those, it's better to do this than not do this approaches, even though, and you're not really learning much about those who you don't know the details about, really, because obviously if you put my, let's say my son's NHS number in there because you don't provide any services to him because he's miles away from anywhere where you are, you wouldn't learn anything about him. No. From what I'm generally hearing there.
No, I agree. I think it is that sort of, it's that balance of data minimization and but recognizing what the need is and balancing that sort of the justification and the privacy rights of individuals. What impact is there going to be on the privacy rights of those individuals by that disclosure of that information to a trusted partner in a health system who have an obligation, a statutory duty to fulfill? If you can't do that, as Adam said, if there is a way to do it, if you had all the time in the world and you could find a way of filtering that list of NHS numbers, that would be your ideal data protection position to be in. But is that a pragmatic and realistic way to approach it? So you might mitigate, identify that in a data protection impact assessment. In our world, we would do that and document that risk assessment, and then you mitigate it, get it signed off by your organisations and partners, and then agree how you're going to do that, share it securely, how you're going to manage that data. If you, for example, if you share it, you don't keep it. If the 20 that you don't have and you don't know the identity of, why would you keep that data? You just get rid and move on. But you can argue it's always a bit of a debate, isn't it, Adam? I think on these things, and you need to understand the sort of the finer detail sometimes.
Yeah, but it's a question of looking at the risk. And the other thing I was going to briefly say, just 10 seconds, is actually, could it work the other way around? Could you per year pull off the NHS numbers of those you are providing those services to and send that to the local authority, and they compare that to the list they've got? I don't know if that might cause other problems in other areas. I don't know. I'm just thinking around the problem.
We'd probably send more numbers the other way than, because actually the percentage of children with an EHCP is 3% of children, and we're probably seeing more than 3% of children. So it probably would be a bigger list.
I wonder whether this is something we need to look at a bit more closely. We did quite a lot of work with NHS England before Christmas around the lists of children who are clinically extremely vulnerable, because as you're probably aware, more children made it onto that list initially than they then wanted to be on the list, and they were trying to review it and pull the numbers down. And there was an issue because the list had been sent to local authorities, to the public health leads, and then we were getting lots of concern from DMOs and DCOs who were saying that the local authority then didn't feel able to share it with them, which is obviously incredibly unhelpful position to be in when you're trying to sort something out. And then there was also another issue where sometimes it had then been shared with the CCG, but if the DMO or DCO is then in the provider, they still don't have it. And then it was a bit of a mess. So it feels as though this is something that actually it would be really helpful to provide a bit more clarity on. So I'm really happy to go away and do that, Sue.
Thank you.
Yeah, just a couple of comments really about that particular issue. Excuse me, I was leading, when I was at the Leeds City Council, I was leading on shielding for children, and the algorithm was applied, the same algorithm for adults was applied to children, and it didn't work at all. So that was the first issue. And the second issue was MHCLG said, you can't share this information with anybody. And I pushed back massively on that and said, schools need to know if a child has been advised to shield. And eventually they agreed that we could share with schools. When we did share with schools, guess what happened? We had head teachers ringing me saying, little Johnny's in school and you're telling me that he's on the shielding list and his parents have sent him in anyway. It was just, the whole thing was just really badly managed. And then, of course, there was no clinical involvement whatsoever in making decisions about which children should be on the shielding list. So once we got our paediatricians involved and GPs involved, loads and loads of children came off the list. because some of the children that were on the list were children who the only condition they had was cerebral palsy, which doesn't have any kind of make you clinically extremely vulnerable, because there's no, other than your physical and movement and things like that, it doesn't make you more prone to COVID. So the second tranche of work that had to be done would have been much better being done the first time around. And it's this thing about children are not small adults, and it really drives me mad. The fact that, that they just didn't consider this at all. Anyway, but MHCLD did eventually agree that we could do that. And we sent out a letter and a data sharing agreement to every council in West Yorkshire to say, you can share this information now with your schools. And schools really welcomed it because they didn't have a clue what was going on. And I'm delighted to hear that this issue about the NHS number is being resolved, because I think it's absolutely the right thing. So thank you for all your work on that.
No, that's fine, Sue, and thank you to Adam and Kevin for I think getting us to a much happier position. I think the sort of explicit consent thing would have just held people up again. So yeah, absolutely. Any final thoughts before we wrap up? Do you want to let you go for your lunch? Sorry, we can't give you lunch. No. Okay, super. I promise I will send the legal judgment to anyone who's asked for it. So if you do want it and haven't put your name in the chat, do that now. Please, you will see that slightly higher up in the chat, Daphne has put the link to the evaluation form. So please do fill that out. As Christine said, DFE really do like to get feedback on how the sessions have gone and how well received they are. So it really helps us, if you don't mind just taking a few minutes to do that. It's not too onerous, I promise. Thank you very much to Adam and Kevin for sharing their wealth of really detailed knowledge with us, which has just really made such a difference on this issue. And thank you to, oh, hang on a minute, sorry, somebody has got their hand up. Michelle.
Yeah, I just wanted to ask whether I could just grab Amanda and, sorry, was it Adam and Kevin. I can't remember Mr. Caldwell's name, sorry, just really quickly after the meet, this catch up, just for 5 minutes, because I've got an issue around consent myself. So yeah, if that's okay. We'll
stay on the call. Thank you very much to everyone else, and as just a quick reminder as well, Daphne and Marie will send around the links to the recordings from all of the other workshops, so any that you wanted to catch up on, you will be able to do so at your leisure. Lovely to see you all, and see you next time. Thanks again, Kevin and Adam. That's okay. I think people have really appreciated that. So job well done.
What was Michelle's question then? Consent?
Yeah, sorry, I just wanted to really grab you really quickly. So I've got an issue within Sheffield where we, as nurses, we are really conscious about getting consent for our contact with parents, because part of our information collation system is on system 1. So we get that explicit consent to be able to open a record for them. However, for some of the tribunal cases, we've had situations where parents have then withdrawn consent. And I just wondered whether, under the exercise of official authority and the fact that it's within law that we have to have that health view, where I actually stand with that, and whether we should even, right at the very beginning of the process, be bothering to get consent at all.
Okay, Michelle, in terms of the consent you get at the beginning of the process, what is that effectively for? Is that to, as you say, open a record, or?
It's to open a System 1 record, because that's how we collate a lot of our health information for response within an EHCP.
And the service you're providing to the children?
I'm the designated clinical officer.
Yeah. System 1, I mean, it's had some issues in the past with the ICO and its consent processes, and I don't.
Mhm.
So is that driven by the system requiring you to get consent, i.e., it's got a box you've got to tick to say you've got consent of the individual, or?
Yes, to be able to open that file, because that's our
Yeah, 'cause-
record keeping system. So everything that I do is logged onto System 1. So
Yeah.
obviously that's then shared with the GP, and it's a very
Yep.
open. It's beneficial to the process, very much
Yeah.
so.
And in this case, then the service you're providing to them is it one that you are statutorily required to provide,
Yes, it
and
is.
they're effectively, by participating with you, are accepting the services being provided?
Yeah.
I'm going to be unprofessional then, so I think the System 1 consent screen is bonkers.
Right, we do.
Why would we need consent to record a record? I mean, I would argue that clinical services, you have a duty to record a record for the care you provide, and
Yeah.
there's nothing more fundamental than that being a
That's
legal
what
requirement.
my argument was. So we can kind of like tick that off then. So in terms of the
I can see
tribunal,
Kevin nodding as well. So.
yeah, brilliant, lovely. So in terms of the tribunals then, where a parent has absolutely not given consent for us to continue with the case, would my argue still remain the same then, that, you know, under the Children and Families Act, we have to, under the statutory duty, support that tribunal process, and therefore we're not able to
So when they withdraw their consent, such as it is, then they're basically saying they wish themselves no longer to participate. But what is, excuse my naivety and lack of knowledge, what is the purpose of the tribunal at that point?
Because if they've got a DCO monitoring and looking at their health information, families use that. If that's not, if they're declining that function, they can use that to their own advantage. That sounds really awful because we're, you know, I'm very family orientated, but for the recent cases, they've not allowed me to participate in the function within the tribunals because we have then access to lots of health information that is contradictory to their plight.
So they are effectively trying to prevent the tribunal from going ahead. That will not.
It wouldn't stop it going ahead, but it would mean that in those cases, parents have often had private therapy reports, for instance, drawn up, which would suggest that their child needs a far higher level of input than has been recommended by the CCG.
So our job is to bring that back in line, really, and just with evidence. So if we've got evidence that contradicts that level of support, which we often find, and this particular case